Good morning and welcome to another edition of Gough Square Live. I'm Lee Finch and to my left is Simon Popplewell. This morning we're going to be talking to you about the GDPR, or the General Data Protection Regulation. I'm going to be manning the live feed throughout the talk, so if you have any questions do not hesitate to get in contact there. Simon is now going to take us through the GDPR and what it means for everybody who's listening.
Thank you, Lee. If you look at slide 1 to start with, you will see that the GDPR is finally upon us, or more or less. It comes into force on the 25th of May 2018, or next Friday. Now, I would imagine most of the people who are having to deal with GDPR fall into one of two camps. You have the early adopters. You have those people who are very organised, get ahead of the game, and have probably been ready for the GDPR for months and months. And then you get camp number 2, which is the people who are probably thinking, next Friday, that does sound a little close. I really need to start thinking about this. Well, normally the early adopters will be a little bit ahead of the game. The problem with the GDPR implementation, however, is that the guidance that we've had has been a little bit limited and a little bit piecemeal. There's two main sources of the guidance on what we should be doing. One is what's known as the Article 29 Working Party, which is a body of European data protection experts, and the other is the Information Commissioner. The Information Commissioner, however, has been kind of limited her guidance until waiting for the Article 29 party to put out theirs, perhaps understandably, but it's led to some problems because the Article 29 party has not been particularly timely with getting their guidance out there. In particular, probably one of the most important areas, or the ones that most people care about when getting their GDPR implementation incorrect, is what to do with their privacy notice, i.e. the document that they show to the public, which says this is what we're going to do with our data. We had the Information Commissioner guidance on that yesterday. I discovered we had the Information guidance on that yesterday this morning. Cards on the table, I have not fully read it yet. So this talk is probably already to a small extent be out of date. It's 49 pages long. It's giving guidance on what is probably one of the most important things to do for your GDPR compliance, and we've got it 6 working days before the deadline. Another example is the Data Protection Act bill, the legislation which qualifies the GDPR in a certain number of respects and sets out a number of categories or exceptions to allow people to process certain types of data. Very important. It has not yet been finalised. As of Tuesday, the Lords and the Commons were arguing about certain amendments and what should go in there. It's not yet had royal assent. We can't be certain what's going to be in it, although we can take a pretty good guess. It seems to me the royal family may have other things on this weekend, rather than necessarily worrying about giving royal assent to the data protection bill. But the consequence for the rest of us is that, well, we still can't be certain, 6 days beforehand, what exactly we're going to have to face. Now, I am not going to today spend the next 15 minutes or so taking you through the GDPR in any detail. Quite frankly, there probably is not enough internet or not enough time. What I'm going to do is to try and talk through some of the practical issues which have come to light as part and parcel of my experience with the GDPR. I've had to come to grips with the GDPR in a number of different ways. I am myself a data controller. So I myself have to comply with it, and I have to make sure that my own practices and procedures are GDPR compliant. I also work for a chambers, or with a barrister's chambers. The barrister's chambers is both a data controller and also a data processor. And for something that I did in a previous life, somehow I have been responsible for the person in chambers, or I am the person in chambers who is responsible for having to make sure chambers is GDPR compliant. I've had to look at it for a number of clients. And I've also made the mistake of admitting to a couple of friends or family and friends that I've been looking at GDPR. So you get the inevitable questions, oh, can you please just look at what we've done for our social club? And if you're looking at this, you know who you are. So that's what I've had to deal with, and that's how I've been looking at it. And so what I'm going to do for the next few minutes is just take you through some of the issues that has jumped out at me. Hopefully you're already a long way, if not there, for your GDPR compliance. If you're not, it might be there's a couple of things here you can think about. If you've already looked at it, it may be something you've missed. So if we start then at looking at slide 2, the first thing I want to talk about is the privacy notices. This is the thing on which we got the guidance for yesterday, which I've only partially read. Your privacy notice is how you tell the public what you are doing with their data, or your data subjects. Historically, it was fairly common just to put a couple of paragraphs in your terms and conditions, which your clients probably would look at or not look at, depending on how diligent they read their terms and conditions, and that was that. That's not going to work anymore for a couple of reasons. Firstly, what I have discovered with privacy notice is they are going to be long. You are not going to have very concise, short paragraphs that you can just slot neatly into a small space in your terms and conditions. This is problematic because the GDPR actually requires your privacy notice to be concise. It's an express requirement. But you simply cannot match that with the amount of content which the GDPR requires you to put in that. And in fairness to the Information Commissioner, this is something which the guidance which I looked at this morning has at least appreciated, that there is a tension between the conciseness of your privacy notice and the contents that you have to put in it. But the other reason why you can't just slot this in your terms and conditions, as historically was the case, is because you are required under Article 13 GDPR, the way you obtain your data from your data subject, i.e. you get it from your customer, well, you've got to give them the privacy notice at that time. For a lot of people, you are going to be getting your customer's information before you actually enter into your contract with them. You may need to do creditworthiness checks, you may need to do know your customer checks, you may just want to take a little bit of time to think about whether you want to enter into it. Well, the contract comes into force when you enter into the force, but you actually need to have given your customer your notice before that. So you can't just slot it in your terms and conditions anymore. Second thing to think about is, well, how are you going to do this? How are you actually going to give your notice to your customers? The guidance from the Article 29 Working Party suggests that in this internet day and age, everybody with an internet presence should be adopting what's called a multi-tiered approach. You should be having almost like a short summary on your web page. If someone holds their mouse over the relevant headings, a box is going to magically pop up on the screen telling the customer or the client exactly all the information which you need. Well, this is all very well and good if you are a large organisation and can afford these IT changes. I can pretty much promise you, if you click on Gough Chamber's website next week, it's not going to do that. Simply because we don't have the IT infrastructure in place to implement the level of detail which the guidance suggests, and which I suspect is going to be the same for a lot of, well, whether it be traders or not traders, whether it be social clubs or anyone who holds their clients' data, are simply not going to have the technological brilliance which is recommended for how to bring this across. So how then do you do it? One thing which I have seen and which I think is a good idea is you in essence have two notices. You have a summary, you have a long form. You say this is your multi-tier approach. You give your client the summary when you're handing them pieces of paper, etc. But you link to your long form document which you have on your website or you have somewhere else. So that's one method I've seen to try and get around this. It is possible you might need to think about whether you need more than one privacy notice. You will have different categories of data subjects. You may have your customers, but you may also have your employees. You may have business contacts. You may have third-party suppliers, people who provide your cleaning, your catering services, things like that. They will all need a privacy notice to some extent, and they will all separately have different bases on which you process their data. So it's possible you may want to think about, rather than having an extremely lengthy document, just have a somewhat lengthy document that you give one category and you do a different document for your other different categories. The danger, of course, is what if you mix them up? But it's at least something worth thinking about. There are problems with privacy notice when you obtain your customer's data not from the customer itself but from a third party, because there's also an obligation in the GDPR to tell the customer about that when you obtain that information. Lots of circumstances you might do this. If you run a credit check on your customers, you're obtaining that information about the customer not from the customer, from the credit assessment agency. If you run criminal records checks, again. But it might arise in other circumstances. What if your customer just writes to you saying, I have got various problems with repaying what I owe you, and this is because my wife has been ill. All of a sudden you're holding that customer's wife's personal data, but you've not got that wife's personal customer data from the wife. In theory, you should be giving her a privacy notice at that time when you've obtained it. Now, there are some exceptions to having to do this. You don't have to do it where it's impossible, although in most circumstances that's probably not going to be the case. You don't have to do it where it involves a disproportionate effort. But again, the guidance seems to suggest you should not be relying on disproportionate effort as a matter of routine. So you need to think very carefully about whether you should be giving privacy notice to third parties. If so, when you need to do this, and if so, how you're going to do it. And a third problem we have with privacy notices, well, what if your notice changes? What if 6 months, 12 months, 18 months down the line, you change your mind on what you want to do with the data, or something else comes along and think, actually, we really need the data for that purpose. Or we're going to change our IT supplier. We need to change the person we're disclosing it to. We're going to change our solicitors. We're going to change any other third parties that provide us with services. Your privacy notice will have changed. How do you communicate that to your data subjects? In theory, you're supposed to proactively notify each of the person who has had the privacy notice to explain to them how it has changed. What you should not be doing is just leaving it on your website, updating it on your website and having a general catch-all paragraph that says, please check this from time to time to make sure it still applies. I have my suspicions as to how that is going to work in practice and how many traders are in fact going to proactively notify their customer base every time they change their basis for processing data. Which might mean one thing to think about now is draft for the future. If you can get foreseen future changes into your privacy notice, it's a good time to do so. Give you a personal example from me. If any of you are Dropbox customers, you may have realised that Dropbox are monetizing GDPR, because while they are making their more expensive business packages GDPR compliant, they are not doing so with their basic packages, which means post next week you can't really use the GDPR for Dropbox for business purposes unless you're spending a fair bit of money on it. That's irritated me quite a bit. I'm pretty sure I'm going to cancel my Dropbox subscription and move to someone else, but I'm not going to get it in place in time for next week because I've got other things on. So I will probably put in my privacy notice that I use Dropbox, and I will take a decision on another supplier and refer to them both just to try and future draft. So what I don't need to do is recontact everybody in a few months' time saying I've now changed my IT supplier. If we move on to slide 3, I'm going to move on to a little bit what is the lawful basis of processing. To some extent, you already should have a lawful basis for your processing. It's required by the Data Protection Act. What the GDPR has done, though, is means that we've all got to think about it, because you're required to set out your lawful basis of processing in your privacy notice. In the past, you've generally been able to justify your use of data retrospectively. If anyone ever takes an issue, well, you've done this with my data, how could you do that? Well, you'd look at the DPA, you'd look at the schedules, you think, oh, if I fall within that basis, I'm fine. But now you need to think in advance, because you need to tell people in the privacy notice how you're going to use their data. And if it's not in the privacy notice, you can't rely on it. So what this has meant in practice is you've got to give a lot of thought to how you're going to use the data, and you've got to give a lot of thought to what is your lawful basis, what is your legal basis for processing it, which again leads to some problems. What can you do about unforeseen events? Well, you're in difficulties. You probably need to change your privacy notice, which then leads back to the problems we just discussed a moment ago, is you've got to notify everyone. I think, having worked through it, there are some gaps in some of the lawful basis that you see in the GDPR when you apply that to sort of everyday life and everyday practice, particularly in the realms of special data, i.e. things like medical data or very sensitive personal data, or even criminal convictions, which is a different category under the GDPR. And there are much more limited bases to process those type of data in the GDPR. And when you try to work it through, sometimes it's very difficult to find a legal basis to process data. For example, if you want to ask your employees for a doctor's sick note when they're off ill, well, you need a lawful basis to do that. But that is sensitive personal medical data. The only exception that seems to fit to any real purpose is consent. Yet the guidance says you can't take consent from an employee in their employment contract, because in essence you're forcing them to do it. They haven't really got much choice. So there is certainly a tension, I think, in the GDPR with some everyday uses that you want to use with your data, and actually then trying to find your lawful basis in advance so you can specify it in your privacy notice. And the other thing that I'm sure we've all been grappling is need for retention periods. You need to be setting out, this is how long I'm going to keep your data for. It's not always an easy question, that. Well, how long do you need it? How long can you justify having it? Those people that like to hoard their data, hoard their documents, well, probably can't do that anymore, or at least if you want to do it, you've got to go through the somewhat laborious task of anonymising it all to take out the personal data. I had a day the other week where I deleted a whole realm of my historic emails, which you keep just in case. So if any of my clients are watching and you want to know what I advised you back in 2005, I'm afraid I can no longer tell you because it is gone. If we move on to slide 4, another issue that I've noticed is the trouble with consent. To some extent, consent seems a very easy way to be able to process data. Oh, I have the customer's consent, therefore I can do it. Well, that's all very well and good to an extent. The problem with consent is consent can be withdrawn. So you need to be very careful about relying on consent as your only basis to process the data. For example, you have a contract with a customer. Your customer gives you a consent to process your data. You think, all very well and good, therefore I don't need to worry about any other lawful basis. You don't specify any other lawful basis in your privacy notice, you just refer to consent. You then get in an argument with your customer, you want to sue your customer for some money, and the customer turns around and says, I withdraw my consent for you processing my data. You're then in difficulties because you have not specified any other lawful basis to process that customer's data in your contract, and the customer has withdrawn the consent. Now, there are likely to be other lawful bases in your contract, but you need to think about them in advance because you have to specify them in your privacy notice. I think you need to be very careful just relying on consent, and if at all possible, I would avoid doing so. Consent also gives rise to certain other rights that the customer has, or the data subject may have: a right to be forgotten if consent's the only way that they're processing data, a right to have their data portability. Now, I'm not for 1 second saying that you should be trying to avoid giving your data subjects their rights, but if you can make your life easier by thinking of alternative bases to process data, it's not a bad thing to do. You need to think about how you're going to capture consent. It's got to be express. Burying it in the terms and conditions is probably not going to work anymore. Think about tick boxes in application forms, things like that. And the guidance suggests as well that you've got to be a little careful with whether consent is true consent. You can't really have conditional consent. You can't say to a customer, if you purchase these goods from me, you therefore also consent to me marketing my services to you, because one does not depend on the other. It's perfectly possible to sell those goods to those customers without also taking their consent for marketing. And so what the GDPR provides is, well, that's not true consent because it's unjustified conditional performance or conditional consent. And as I've already indicated, there are certain situations when the guidance says you shouldn't be looking for consent at all, for example, in the employment scenario. We look at slide 5. You need to be giving careful thought to, well, how can you show that you are in fact GDPR compliant? It's not enough anymore to be compliant. You have to be able to show that you're compliant. You have to be able to demonstrate it. There is a specific requirement to do that in Article 24.1 of the GDPR. Well, how are you going to do this? Paper. Documents have policies in place that says this is what we do, this is how we do in these circumstances. Have audit trails in place to show that you can make sure what you're doing in practice. Have records of your data processing. Have records of what happens if a customer exercises their rights. They make a data access request or they ask for a right to be forgotten. Think very carefully about your paper trail, and so that if anyone ever does come knocking and say, how can you show that you are compliant with the GDPR, you can say, oh, we've got all this paper, here you go. While the GDPR does require you to demonstrate compliance, and the nature and scope of the processing is relevant to how you do that, it's noticeable that sort of the size of the data controller is not. So these need for policies, practices, procedures, they apply just as much to the small corner shop, the tennis clubs, the drama clubs, the individual sole traders, as they do to the large scale organisations. So think very carefully about whether you can demonstrate consent if you have to. Demonstrate compliance if you have to. And the final slide I want to talk about a little quickly is third-party processor issues. The GDPR puts certain mandatory clauses which you must put in any contract that you have with someone who processes data on your behalf. You don't have any choice. These have to go in there. all very well and good, apart from while there is provision in the GDPR for there to be sample clauses sort of published by, I think it's the Commission, they're not out there yet, so we don't know. So you've got to get the lawyers to draft them for you. And secondly, there are also problems about identifying who your processors are in the first place. There's a lot of people who might be processors who instinctively don't feel like they're processors. Your cloud service provider, your email provider, your typist, your bookkeeper, your pupil. We've had that as an issue in Chambers. My pupil was very happy when I put the processor terms in front of her and asked her to sign her life away in terms of what she did with our Chambers data. You need to think about who these people are. You need to make sure that you have terms in place with them, which is all very well and good when you have either inequality of bargaining power or a inequality of bargaining power in your favour. In reality, if our pupil had not signed the processing terms I put in front of her, she was going to be in difficulty. But what if the inequality goes the other way? I mean, can you really dictate to Dropbox, to whoever, this is what you need to put in your terms? Probably not. Now, in my experience, most organisations are alive to GDPR. Most organisations are alive to this, and most organisations are at least trying to get something in place. The difficulty you have is what if you're relying on an organisation or using the services of an organisation that doesn't. In theory, you need to be ending that service before next Friday, because otherwise you will not have the terms in your processor contract. So you need to be checking your processor contracts, making sure they're compliant, and if they're not, you need to be giving some thought to what to do about it. And that is that. Thank you.
Thank you very much, Simon. We've had a number of questions on the live stream. I've answered some of them. I've also received some by email. One that I think I'll pass over to you is we've had a question from a trading standards officer, which is that the Citizens Advice Consumer Service have now informed that Trading Standards Department that they are no longer going to be asking consumers for consent to enable the Trading Standards Department to communicate with the relevant trader about a given complaint. Now, it seems to me I'm not entirely sure why the Citizens Advice Service have decided that GDPR means they can no longer ask for that consent, but I'm just wondering if you can think of how that can be dealt with in practice, given that's the situation.
Yes, I'd agree. It's difficult to see why the GDPR means they can't take the customer's consent, but if you don't have the customer's consent to pass the complaint on to a trader, there are probably other legal bases on which you can rely on to do so. If it's a potential criminal offence that you're investigating, you probably have certain obligations under, for example, the Consumer Protection and Fair Trading regulations to actually investigate, and so you can say that you are under a legal obligation to process the data. You might be able to rely on a public interest. It's in the public interest to look at these things. You may well just be able to say you have a legitimate expectation, or a legitimate interest, I should say, in processing this data. You'll find with some of those it might be necessary to balance up the rights, however, particularly with legitimate interest. You've got to perform a balancing exercise between your interests and the interests of the data subject. Ask yourself, do you really need to disclose the customer's data to that trader to be able to investigate? Can you do it in an anonymous way? If you can't, then yes, I imagine you probably has a lawful basis of processing that you can rely on.
Thanks, Simon. And finally, another question that we've received via email. What's going to happen when people inevitably get some of this wrong?
I've heard anecdotally, I'm not going to put it any higher than that, I've heard anecdotally that the Information Commissioner is alive to some of the issues and has said that they're going to be looking for heading towards compliance rather than actual compliance come next Friday. But of course there is going to come some point when you should be having your house in order and you should be making sure you've got it right. If you get it wrong, number of possible consequences. Big one being you can be fined, and the levels of fine are quite high. I think it depends a little bit on what your breach is, but for the worst case scenario, there's a fine of up to 20 million euros, or I think 4% of your annual turnover, which is a pretty big stick to hit you over the head with. You can also potentially face civil action if anyone has suffered loss or distress as a result of you not complying with GDPR. Then they can sue you and try and recover that through the courts.
Thank you very much, Simon. Well, that's just about all we have time for today. There'll be another Gough Square live in a fortnight's time. Please join us then. Thank you.
Thank you.